Good afternoon. My name is Jason Starr, and I'm an attorney with the New York Civil Liberties Union. I am also a 3-year resident of Brooklyn, New York. On Tuesday, February 19th, shortly before 10 p.m., I was stopped by 2 uniformed NYPD officers near the corner of Atlantic Avenue and Carlton Avenue in Brooklyn. The officers told me that I resembled a robbery suspect and that I needed to remove my jacket and consent to a search in order to determine whether I was indeed the guy. Instinctively, I lifted my hand slowly in the officer's view. And then I did something I've never done before. I replied calmly but forcefully that I did not consent to any search of my person or my belongings. I told them that if they had the legal reason to do what they wanted to do and frisk me, if they were actually afraid that I was going to harm them, that they would not need my consent. I fully expected to end up against the wall anyway, and I thought that they might perhaps rough me up in the process. I was lucky. I don't know why those officers actually stopped me, or why, in that instance, my refusal was enough to make them back off. I did not share the fact that I am an attorney or a staff member at the NYCLU, but I do recognize that I'm privileged. Educated, able-bodied, I have access to resources, knowledge of the criminal justice system, and the list goes on. Sadly, for so many other black and brown people who aren't doing anything but walking to school or the subway or to work, people who don't have the same privileges as I, these humiliating and traumatizing encounters do not end as positively as mine did. And though my experience had a relatively happy ending, I exercised my rights and I got to walk away. I did not leave the encounter feeling triumphant. I ran all the way home, frightened that all I had done was give these patrol officers a reason to target me in the future. To this day, nearly 2 months later, each time I pass that intersection, I tense reflexively. I'm also deeply angry, an emotion that I have to control every time I see a police officer. And my personal scars are relatively minor. Too often, others bear scars even deeper and more permanent than mine, both physical and emotional, simply because the NYPD is out of control. The NYPD acts with a culture of impunity. This undermines the ability of the community to trust and respect the police department, making all New Yorkers, black and white, rich and poor, young and old, immigrant and citizen, queer and straight, less safe. How much longer does this need to go on? It's time for New York City and the Bloomberg administration to admit that it has a stop-and-frisk problem, to settle its stop-and-frisk cases, and to agree to serious reforms, including passage of the Community Safety Act. What happened to me on that night should not be a part of daily life for any New Yorker.
Juana Johnson from Legal Aid Society, criminal practice in Manhattan.
Good afternoon, everyone. My name is Juana Johnson, and approximately 2 or 3 years ago, I worked at the Juvenile Rights Division, Juvenile Rights Practice in the Bronx. I've been asked today to talk about a case in which police officers stopped a client of mine and frisked him. When my office got word of the facts of this case, everyone there urged me to take the case to what's called a suppression hearing, because we felt at that point that these youngsters in the Bronx, these black and brown youngsters in the Bronx, were going through this too much, and that the court needed to hear the information simply because the stories needed to be told. The officer came in on my case, and he testified that the reason why he stopped my client was because he was in an area where there had been gang violence, and that their motive that day was to canvass the area and to talk to people about what was going on in the area with regards to gang violence and shootings. My client exited a train station, and the officer testified that he had a cell phone in his hand that the officer could see, and something else that he visibly couldn't see. He said that coupled with the fact that my client was in the area at 11:30 in the morning on what should have been a school day, or what he perceived was a school day, he came over to have what he considered to be friendly conversation with him. From that point on, the frisk began, and then the search began. Specifically with regards to challenging that officer, the questions that I posed to him and the questions that I urge lawyers to pose to these officers begins with why the stop. Essentially, why did you stop him? When he said that he stopped him because he was in a bad area, case law has been brought out. I believe the case is People v. McIntosh in 2001, where a judge said that geographical profiling is not constitutionally acceptable. In other words, you cannot stop someone because they are in a bad area. Unfortunately, our clients live in bad crime areas, but exiting a train station in a bad area does not bring about a reason for a police officer to stop you. When he talked about friendly conversation, my challenge to that was the idea that this was a 14-year-old kid who's walking towards a neighborhood, and a cop shows up in a van, jumps out, and prevents him from walking any further and considers that friendly conversation. While this is going on, you ask the cop, you should challenge the cop, where were your hands? Were they placed near your gun? Were they standing by your side? Because if not, you're talking about a 14-year-old who is going to start to stutter and feel uncomfortable because he has been approached by a police officer. When the police officer testified that he stopped him because he should have been in school, my question surrounding that issue was specifically, you are a police officer who does this kind of work. You canvass areas specifically for juveniles and for issues with gangs. Well, if you have been doing this for this long, and this has been your modus operandi that day, did you not stop to think or stop to question whether or not this was a school day? Because in fact, it was not a school day. So my client walking around at 11:30 in the morning with a backpack was justified because there was no school that day. Further, he said that my client began to stutter and when he asked him questions. He said that he asked him to go into his pocket and my client complied. When my client went to go into his pocket, then he testified that he was in fear of his safety. Well, if he's going into his pocket because you asked him to go in his pocket and show you what he had, and then he reaches for his pocket and you say that it's fear of safety, at that point your testimony starts to fall apart. Further, he testified that at some point he said to my client, can I tap your pocket or can I touch your pocket? Well, my client is a 14-year-old kid in the Bronx who has never had any cop contact. He says, fine, you can tap my pocket. He proceeds to tap the pocket, testified that he was not in fear of his safety at this time. The other officers were still in the van. He's tapping my client's pocket, and then he proceeds to go in the pocket. So when you begin to question these rogue officers, what I would suggest that we do as lawyers is that we take them to task on step by step. Why are you stopping this person? What are you intending to ask this person? If the person isn't answering the questions correctly or to your however you feel they should be answered, then what is your next step and why is the reason for that next step? So step by step we question them as to what they're doing. This officer clearly had no real answers. His story began to fall apart throughout the testimony. However, when the judge made a decision, because this is a police officer's word versus a 14-year-old, the suppression hearing, the suppression was not granted. And at that point, when the suppression isn't granted, then you have the option of going to trial, as you know, or not. But the information that we received in this hearing, or the information that we wanted to get across to the judge, was that whether or not you find something on someone, we're talking about constitutional rights. And to stop someone and to frisk them and to not have any reasonable suspicion that criminality is afoot is a violation of their criminal rights and a violation of their constitutional rights. And at that point, the courts need to understand that these young people in the Bronx and Brooklyn and all over the city are being approached by these rogue cops, and it's starting a relationship of hostility that travels with them throughout the rest of their life. And at that point, when we justify these things, when courts justify these things, when judges justify these things, what they're doing is they're giving these rogue cops a pass to do whatever it is they want to do. Thank you.
It's just a perfect opportunity to follow Tawana, because her story about what happens when these cases are litigated points out to me what I just want to spend a couple minutes talking about. You know, we know right here the ongoing Stop-and-Frisk litigation in the federal court points to a larger issue, the invisibility and the willful irrelevance of the New York City Criminal Court, the first-tier trial court. And while many have critiqued the NYPD, the police commissioner, the mayor, for the plague of rampant stop-and-frisk that impact young men of color in disproportionate and disturbing numbers, few have turned their attention to the criminal court just a few blocks down from here. And one would expect, if not demand, in a city of 685,000 stops and frisks, that there would be innumerable suppression hearings, exactly like Tawana's case, going on daily, thousands, tens of thousands, with officers called to testify under oath about what they did and why they did it. And after all, this is it is exactly the role that the Supreme Court envisioned for the criminal court 40 years ago when it determined in Mapp versus Ohio that suppression of evidence was necessary to deter police officers from committing unreasonable searches and seizures. However, as the people behind me know much better than me, suppression hearings in the criminal court are few and far between. Just as the criminal court's overarching emphasis on efficiency in plea bargains trumps trials and anything resembling meaningful determinations of guilt or innocence, it also ignores, if not outright abhors, suppression hearings and careful examinations of the legality of everyday police conduct. And by abdicating its critical oversight role, the criminal court bears responsibility for effectively shielding police behavior from any meaningful external accountability. And while the Supreme Court in Terry versus Ohio did, as we know, it did expand police power greatly, nevertheless, fault for the runaway stop-and-frisk train lies to a great extent with the trial courts. And by consistently refusing to review and regulate the police, the courts have paved the way for Terry to become exactly what it has, an unrealized constitutional protection, a shield, not a sword. And even as we learn about the staggeringly high number of stops and frisks inflicted on innocent men of color, the criminal court plows ahead with business as usual and nary a suppression hearing in sight. And almost 30 years ago, there was a scathing report, which I know many of you are aware of, about the criminal court, where it noted that about 0.5% of all misdemeanors actually go to trial, and the report asked rhetorically whether such an institution could rightfully even be called a court. Well, now it is appropriate to ask as well whether a court that fails to hold a meaningful number of suppression hearings can rightfully call itself a court. And the lack of suppression hearing litigation is particularly troubling in light of Terry itself, the very case at the heart of the Floyd litigation. The Supreme Court stated, and these are words from Terry, under our decision, trial courts, the criminal courts, still retain their traditional responsibility to guard against police conduct which is overbearing or harassing or which trenches upon personal security without the objective evidentiary justification which the Constitution requires. I think anyone familiar with the criminal court would hardly describe that as the role of our present courts. As District Court Judge Jack Weinstein wrote regarding Terry itself, active policing of the police by the trial court serves a necessary and vital function. And yet, the criminal court is more concerned with efficiency and moving its calendar. Know too, as you all do, that the prosecution for its part has also been relatively unscathed in this litigation and has shown very little appetite for subjecting their cases to independent judicial constitutional scrutiny, and as we all know too well, typically threaten heavier plea offers if the defense insists on asserting constitutional rights. And the long-standing prosecutorial and judicial abdication of that vital function of policing the police is particularly unconscionable in the face of unprecedented numbers of stops and frisks. And put simply, it is indisputable that if the criminal court was doing its job, if the prosecutors were doing their job, the stop-and-frisk explosion would have been uncovered and addressed years ago. The silence in the criminal court must no longer be tolerated. Silence in this context is more than merely looking the other way. It conveys tacit approval. It has served to encourage the NYPD to conduct more and more stops to have any legitimacy whatsoever as a court. The criminal court must finally play the watchdog role envisioned for it by the Supreme Court. And I should say parenthetically that I hope as a group, if the criminal court maintains its unwillingness to play this particular role, we should ask, where is the legislative branch? Why don't they step into the breach and hold hearings? Or perhaps, given the popular unrest occasioned by stops and frisks, the time has come for some kind of truth and reconciliation process to fully vent the purported justifications for and to give voice to the consequences of the practice. Excuse me. A few years ago, as some of you may know, the NYPD created an explanatory stop and frisk card. I don't know if anyone's... to give out to those they stopped and frisked. And at the bottom of the card, after listing reasons why people are stopped and frisked, it says, and I'm quoting, because this one, you really can't make this one up. If you have been stopped and were not involved in any criminal activity, the NYPD regrets any inconvenience. Being spread eagle on a police car in front of family and friends, or the situation that Jason described. as police officers go through your pants and pockets is not what anybody would call an inconvenience. So in addition to demanding more and better the police, it is essential as well that we demand much better from our criminal courts, giving the accused his or her day in court, listening to the evidence, granting suppression as warrant, will go a lot further toward restoring constitutional faith and constitutional rights than turning a blind eye or even giving out an informational card. Thank you.